Hakan Çakır Günay's YouTube channel. Today we are going to talk about the appointment of directors in limited liability companies under Turkish law. The director or the board of directors, or the board, is the management and representation body in limited liability companies, or LLCs, while the General Assembly is the company's decision-making body. Directors are authorized to take decisions on all matters related to the management that are not reserved to the General Assembly by law or by the Articles of Association, or AOA, and have the power to execute these decisions. There is no hierarchy between the General Assembly and the board. Under Turkish law, there may be at least one director or a board consisting of more than one director in an LLC. Directors are one of the compulsory organs of LLCs, and their absence is a reason for the dissolution of the company. Directors can either be appointed by the AOA or by decision of the General Assembly. The management and the representation of the company are regulated under AOA, and the first directors must be named in the AOA at the incorporation phase. Pursuant to Turkish Commercial Code, the management and representation of the company may be assigned to one or several shareholders, or to all shareholders, or to third parties within the AOA. Moreover, at least one shareholder must hold the title of director. The directors may be appointed for a certain period or indefinitely. The term of office of the directors appointed for a certain period expires upon the specified term. The management and representation of the company shall be regulated by the AOA under the principle of elected management, just as in joint stock companies. The appointment of directors is one of the non-delegible powers of the General Assembly, and the General Assembly shall decide on this issue with the majority of the votes represented at their meeting. The General Assembly is not required to exercise this power immediately, as the first directors of the company is appointed in the AOA at the incorporation stage. When the term of the directors appointed by the AOA expire in any way, new directors must be appointed. Term of the first directors do not necessarily have to be terminated for an appointment by the General Assembly. New directors can be appointed without the removal of the first directors. The directors of an LLC may consist of one or more real persons or legal entities. A legal entity can become a director. However, a real person must be appointed with the full capacity by the legal entity for representation. Turkish Commercial Code requires at least one of the directors of an LLC to be one of the shareholders. In the case of a single director, the director must be appointed from among the shareholders of the company, and in the case of a board, one of the directors must be appointed from among the shareholders. It is not possible to leave the management and representation of the company entirely to persons who are not shareholders. Provided that it is not contrary to the mandatory provisions, it is possible to require certain qualifications by the AOA for the appointment. In this case, the persons who will be directors will have to meet these qualifications in order to be appointed. Thank you for listening, and hope to see you in our next video.